Thank you for joining us, everyone. It's a pleasure to present to you on behalf of the Privacy Law section of the California Lawyers Association, the Code in Court, a fireside chat on NetChoice's challenge to the age-appropriate design code. Before we get started this afternoon, we have a few housekeeping items. First of all, this is supposed to be a dialogue, including with you, the audience, so please feel free to ask questions at any time. The Q&A feature is available for you. We'll be reserving time at the end for questions as well, but depending on the flow of the conversation, I'm hoping to add those in as appropriate during the course of our talk today. Of course, the usual legal disclaimers here. The speaker's comments today do not necessarily represent the views of their respective employers, NetChoice, Davis Wright Tremaine, the New York Times, or the ACLU. And today's presentation is for informative purposes only and does not constitute legal advice. Today's presentation is hopefully part of a two-part series. Today's will feature the perspective of the plaintiffs in litigation challenging California's age-appropriate design code. We're currently working on a hopeful second part of the series representing the views of those defending the code. So keep your eyes peeled for that. But today we will be exploring challenges to the code. I am Cody Venzke, a senior policy counsel of the American Civil Liberties Union, and I will be your moderator. I am pleased to be joined by Chris Marchese, the Litigation Center Director at NetChoice, Adam Sieff, counsel at Davis Wright Tremaine, and Dana Green, senior counsel at the New York Times. I'm going to give each of our speakers a brief opportunity to say a little bit about themselves and what they do. And we will start with Chris. All yours, Chris.
Excellent. Thank you, Cody. Hi, everyone. My name is Chris Marchese, and I'm the director of the NetChoice Litigation Center. NetChoice is a trade association based in Washington, D.C., and our members include just about every major tech business in America, including Google, Meta, as well as Etsy, eBay, Pinterest. So we represent a very broad coalition of businesses interested in protecting free speech and free enterprise online.
Excellent. Thank you, Chris. Adam.
Thanks, Cody, and thanks everyone for joining. My name is Adam Sieff. I'm a counsel at Davis Wright Tremaine. I'm a media, First Amendment, and constitutional litigator here. I have the privilege of representing Chris and NetChoice in this litigation, and I also represent clients in cases involving online speech and censorship, as well as other cases involving constitutional litigation challenging state laws.
Great. And Dana.
Hi, everyone. Thank you very much for having me and for hosting this. Dana Green, I'm senior counsel at the New York Times, obviously publisher of the New York Times, as well as podcasts, documentaries, and other content. And I'm a litigator for the Times. My background is as a media, First Amendment, and constitutional law litigator, and I work closely with our newsroom on all aspects of our publishing.
Excellent. Again, big thanks to all of our speakers today. It's a pleasure to have them, and we feel very fortunate to have such expert voices speaking on this important issue. The bulk of our conversation today will be around our speakers, but we wanted to provide a little background since maybe not everyone is familiar with the age-appropriate design code in California. We have a few provisions here that I'm going to run through fairly quickly and have our speakers weigh in after I've given a brief overview. First, the age-appropriate design code in California applies to any business that provides an online service, product, or feature likely to be accessed by children. It imposes 10 affirmative obligations and 8 prohibitions on businesses that are covered by the code. I'm not going to run through each and every single one of those, but I wanted to highlight a few here as they are relevant to the challenge. First, some of the affirmative obligations include conducting a data protection impact assessment. This is not a traditional privacy assessment, but instead regards features that could expose children to harm or potentially harmful content, conduct, and contacts. And the quotes there are important. That's not simply a paraphrase of the code, but the actual language that it uses. In building off of those data protection impact assessments, businesses must also create a mitigation plan, which they must provide to the California Attorney General upon request. Similarly, the code requires covered businesses to estimate the age of users with a reasonable level of certainty appropriate to the risks posed by the content, conduct, and contacts on the platform. And last, they must enforce published terms, policies, and community standards established by the business. There's also a separate series of prohibitions, which include information that is the use of information in ways that are materially detrimental to the child, a prohibition on profiling, and a prohibition on collecting or retaining data not necessary for the requested feature. I want to dig down just a little bit more on the definition of a business that provides an online service, product, or feature likely to be accessed by children. Likely to be accessed by children is defined in the code. And you'll see here that it starts off with existing law, namely online services that are directed to children as defined under the federal Children's Online Privacy Protection Act. It goes on to identify a number of other factors, which I've highlighted here, and I'm not going to run through them all individually, but it's worth noting that many of these features here bear similarities to the definition of directed to children under the federal Children's Online Privacy Protection Act. At this point, we do not have guidance from the California Attorney General on the exact dimensions of what it means to be likely to be accessed by children, but the act does enable the Attorney General to provide that guidance. If it's forthcoming, we have not yet seen it. The design code is coming in the context of other legislation to address children online. At the federal level, we've seen a number of proposals, including the Kids Online Safety Act, the Kids Privacy Act, that's not a typo, that's the actual acronym without the A, an update to COPPA that's often referred to as COPPA 2.0, and a bill that amends Section 230 known as the Earn It Act. We're also seeing efforts in other states outside of California. The efforts in the other states take on a variety of approaches, including comprehensive privacy legislation that is passing in a number of states, which often include child-specific provisions, laws that purport to address addictive design on social media platforms, laws that impose a minimum age for accessing social media, and then finally, laws that require an age gate, that is requiring proof that you are above a certain age to access content that's harmful to children. Harmful is in scare quotes here for a couple of reasons. One, although the California Design Code does also use the term harmful, the California Design Code does not define that term, as we're going to be exploring here shortly. Some of the laws we cited here do take efforts to define harmful and do so by mimicking the standards that have been articulated by the Supreme Court in cases such as Ginsburg v. New York and another case originating out of California, Brown v. Entertainment Merchants Association. It's important to note that those definitions in line with that case law are largely limited to pornography or pornographic content, especially visual representations. And I use the word mimicking here because we can't say yet whether or not quoting those standards will be enough to survive constitutional scrutiny, but they have at least copy and pasted from that case law. I'm going to pause now and see if our speakers have any other context or commentary that they'd like to add to this background before we dive on in.
Sure. So I'll jump in and just say, obviously California likes to be at the forefront of a lot of different laws. It was the first state to pass a comprehensive data privacy law, which is why this is an interesting situation we find ourselves in, where the state is claiming that its comprehensive privacy law does not protect children meaningfully enough, and therefore we need this. But what I think viewers should know is that this law is not actually about protecting privacy. I mean, perhaps that is what the goal that the lawmakers had when they passed it, but ultimately the effects of the law are to regulate online speech. And I think today's panel will go into the details of why that is. But just right off the bat, I think it's important to note that this is really not a privacy law. At least it's not a privacy law that resembles anything that we've seen really in the US, and it's not even like California's general privacy law. And I think also, we're going to see today during the panel that the law doesn't really just apply to social media, right? A lot of the write-ups about this law in our lawsuit have focused on social media, but as we'll see, this really applies very broadly. It covers the majority of the internet. And I think, folks should be aware that this isn't just about data collection. It is about the speech that is hosted online. And I'll just end there.
Two quick points to add to what Cody said a moment ago. unlike COPPA, and we'll talk about this in more detail. On the last slide, I think that maybe there was or maybe it was this slide you were quoting what COPPA covers versus what this statute covers. I think it's important to understand that it's explicitly in the text that there you go. The scope of the law is not limited to what COPPA covers. So you see an A, which is a direct pull from the statute. That's COPPA. So it applies to the law. Initially says the standard by which one determines whether the law applies to them. Only one of the criteria is whether you would be subject to regulation under COPPA. There's a whole host of others, right, that follow that. So as a result, the law's scope is just inherently much broader than what COPPA requires, which has implications for our COPPA claim that we'll talk about in a second. The second thing I wanted to mention has to do with the ensuing slide. With respect to statutes in other states, Cody mentioned that some have quoted the Ginsburg standard in their text in an attempt to define harmful in a way that might elide constitutional scrutiny. Whether or not that's sufficient, as Cody said, I think that the important point is that the important point in our case, at least, is that California doesn't even attempt to do that. In that, whether or not it would solve any problems, I don't think it necessarily would. But at a minimum, the fact that the term is undefined leads to a host of problems that we could discuss in a moment.
Excellent. So let's go ahead and dive on into the actual meat of our discussion here. First, I want to provide folks a foundation to understand what are the interests involved here. From a legal standpoint, that might be a question of why does NetChoice have standing to challenge this law? So let's go ahead and start with our plaintiffs. Chris, you did a little bit, but can you tell us more about NetChoice? Who does it represent, and what are the interests at stake here in this suit?
Absolutely. So first, I want to clarify, NetChoice really only represents NetChoice, right? Like at the end of the day, we speak and represent ourselves, but of course, we're a trade association of tech businesses, and our mission statement is to keep the internet safe for online free speech and free enterprise. So in that context, we are representing our values and our principles. And for over 2 decades, we have brought lawsuits whenever we see, lawmakers infringing on the open internet. And so the interests that are at stake here are basically, a ton, right? It's affecting free speech online. It's also affecting free enterprise online. But in terms of standing, we sue on behalf of our members, and we have standing through our members. And we also, of course, have association standing. But ultimately, the rights that we are vindicating are the rights of private businesses to exercise their First Amendment right to editorial discretion, primarily online. And so, in a nutshell, this basically means that we are going to challenge laws that, infringe on our members' ability to, do content moderation as they see fit, to design services as they see fit, to, innovate online as they see fit. But ultimately, the rights that we are vindicating are the rights of websites, platforms, apps, and so forth. And I think, that's an important distinction to make, because a lot of times we hear from our opponents that, oh, like big tech, you guys are a censorship regime and, you're infringing the First Amendment. But of course, as any lawyer knows, the First Amendment prohibits the government from violating free speech. And of course, our members as private businesses have their own First Amendment rights. And so that is, where our cases take us. And that is what we are building up a body of case law, both in this case and the other NetChoice cases.
Excellent. Thank you, Chris. Dana, you filed an amicus brief in the litigation on behalf of the New York Times and the Student Press Law Center. Those might be unexpected appearances for some folks. Can you tell us a little bit about why the New York Times and the Student Press Law Center filed an amicus brief and what their interests are here?
Yeah, sure. So, as you and Adam and Chris, I think, have already highlighted, perhaps a misconception that some listeners might have is that this code only applies to social media or to a limited sort of sphere of websites. But if you go back to the language that you highlighted about businesses that are subject to the Act, it's actually extremely broad, much broader than many of these similar, privacy bills have been. So we can start with the fact that there's a very low threshold for annual revenue. Any business that has over 25 million in annual revenue is subject to the Act. That would include all essentially mid-sized and up press organizations. And the definition of likely to be accessed by children is much broader than most other legislation. Children is defined as anyone under 18. In most legislation, it's a lower age, usually 13. And in the language I think that you highlighted, things that are in the statute considered to be attractive to children, likely to be accessed by children, are things like games, comics, celebrity news. Most news organizations have this kind of content. And so, I think somewhat unexpectedly, this act would likely regulate most news organizations, most mainstream news organizations. And, we'll get into it in a minute, but as you've also highlighted, this is not just a design regulation or a privacy regulation. This is very much, by the plain language of the statute, a content regulation. That it is requiring these businesses to identify, and not just identify, but mitigate and eliminate the risk that anyone under the age of 18 is encountering content that is harmful or potentially harmful to children, and who gets to decide what is potentially harmful to those under the age of 18 is left up to the regulator. And so for news organizations, functionally what that means is that a news organization needs to either attempt to create news content that a regulator of whatever sensitivity considers to be appropriate for young people, or they'll need to age gatekeep all users, because in addition to sort of requiring that you limit access for those under age 18, the act also prevents you from retaining data about those users. And so you could not, from visit to visit, for example, know and track that a person is under or over 18. And so potentially every time that every user visits the website, they would need to recertify that they are over the age of 18.
So it sounds like that there are both for the New York Times implementation barriers as well as constitutional concerns. And Adam, as our litigator here, can you help us understand what are the constitutional values that are implicated in this case? Dana and Chris have already touched them a little bit, but can you give us a little bit deeper view of what we're looking at here?
Yeah, so doctrinally, I think that the most important issue concerns the continued vitality of the internet as a medium to which the First Amendment applies without qualification. The Supreme Court in Reno, that was its holding, that the First Amendment applied to the internet, quote, without qualification. And the significance of that holding was that the court, for the first time in 1997 in that case, was deciding whether to treat the internet like broadcast or radio or cable, or to treat it more like the traditional printing press. And the court, in a well-reasoned opinion that has been affirmed and applied for the ensuing 26 years, held that the technological differences in cable, for example, or with broadcast radio frequencies, those don't exist with the internet. And there was no comparable basis, either due to scarcity and bandwidth or due to the sort of monopoly tendencies of cable infrastructure, to restrict or cabin the degree to which the First Amendment applied to internet speech and to publishers and providers of internet services, which facilitate and host the speech of others. And so what we're seeing with laws like the Design Code, and a spate of other laws that you referred to in the opening slides, Cody, is that state legislatures are testing the continued vitality of that principle. And cases like ours, as a First Amendment lawyer, I feel are important because they will determine whether or not the First Amendment continues to apply full-throatedly to speech that is uttered and to speakers who wish to access speech on the internet, or whether governments and other types of censorship can interfere with that access and access to information into that ability to speak and reach wide and unimaginably broad audiences.
Yeah, a very, very powerful note that the Supreme Court precedents, in contrast with challenges to FCC regulations over broadcasting cable and Pacifica and Cox Broadcasting, treated the internet as a different medium. And there seems to be some effort politically to reevaluate that. So I think that's an excellent setup here. So Chris, I'm going to put you a little bit on the spot. As I said, the idea is that this will be a two-part webinar. And so hopefully these folks will get the opportunity to champion their defense of the code. But on the other side of the ledger is the focus of the bill, which is online services responsibilities toward kids. What is your response to claims that the design code is necessary to protect kids online?
Sure. So first, I think it's worth acknowledging that across the country, at both the federal level and the state level, lawmakers are genuinely concerned about how teens and minors are using the internet. I think parents have genuine concerns about the effects that, using devices all day might have on their children's self-esteem, their happiness, and so forth. And I think that that's all valid. And in fact, our members take all of this very, very seriously, not to be too blunt about it, but at the end of the day, it is not good for business to have a website that is going to put children in danger, right? And so even that business rationale aside, it's just the simple fact that our members are in the business of trying to create and foster a safe, enjoyable online environment for users of all ages, or at least users of all ages that are allowed to use their websites. And so, as a basic matter, we're in agreement with lawmakers that we want to make sure that the internet is safe for all users. Where we disagree is obviously over the specifics. And I think, it is a bit of a false choice to say that it's either going to be something like California's age-appropriate design code or you don't want to protect children. And unfortunately, we have seen the debate sort of move in that direction, where a lot of proponents of AADC have basically accused us of not wanting to prioritize children's well-being or minors' well-being. And that's just false. Our members take it very seriously. If you look, there is a ton of services and options available for parents to implement to make sure that their children's use of social media, as well as other websites, is as safe as it can be. So I think, what I would say to people who are very concerned about the internet, yeah, we share those concerns. And I think that there does need to be, it's going to sound so cliche, but there should be a national dialogue about, how we use the internet, how we are engaging technology more broadly. But I really think that we are missing the picture by sort of, honing in only on social media and forgetting that actually for a majority of minors, they have a positive experience online. They report positive effects from connecting with their peers and from connecting with content that is relevant to them. But of course, it is those cases where, people are reporting negative effects that we have to take seriously. And I think, the way to sort of do that is to go through the education route. I was born in '93, and I remember very well being in elementary school and learning how to use a keyboard and a mouse and Microsoft Paint. And I don't mean to be trite or anything, but that was new technology back in the '90s, and we taught it in the public schools. And I think today, the answer to a lot of concerns is to teach responsible internet usage in the schools, right? I think that students should be empowered to use technology, not kept entirely offline, or to have a sanitized online environment where content for both minors and adults is basically the bare minimum of what can get by regulators that might have completely different sensitivities than the rest of the people. So I want to make sure that, folks listening at home know that we do think that this is a problem. We do take it very seriously, but ultimately the answer can't be the state kind of substituting its role for parents, or for that matter, just general users, right? The idea that you can have one standard that is going to, apply across the board for anybody who's under the age of 18 is ridiculous, right? 5-year-olds, what is in their best interest is a lot different from what's in a 13-year-old's best interest from a 17-year-old. And so I really think that the solution here is to sort of come up with educational components, and also making sure that parents are aware of what features and services are available to them for their kids. But ultimately, legislation like this is definitely not the answer, in no small part because it's unconstitutional.
I appreciate that overview. So moving from the sort of 10,000-foot view of the interests at stake, let's dive into the merits of the case. So let's kind of start where we are. Adam, Can you talk to us a little bit about what is the current posture of the case?
Yeah, so our preliminary injunction motion is fully briefed. We have a hearing on July 27th. I see my co-counsel, or one of them, is in the attending the hearing, so we'll see them in court in San Jose on July 27th. And we have a hearing before Judge Lapson Freeman, and she'll rule on our motion at some point. And we've stipulated to stay the government's obligation to file a responsive pleading until we've got a ruling on the preliminary injunction motion. So we'll see how the hearing goes, we'll see what the order is, and we'll go from there.
Excellent. So turning to the merits and the claims in the case, there are a number of doctrines raised throughout. We're going to touch on a few of them. I encourage folks to take a look at the complaint and the briefing if you want to look at how constitutional law intersects with technology law. But let's focus first on the First Amendment claims in the case. Reviewing the complaint in the preliminary injunction briefing, I count 8 distinct lines of First Amendment doctrine: prior restraint, content-based discrimination, compelled speech, vagueness, overbreadth, restriction of editorial discretion, the right to collect information, and the right to address an audience. I hope Adam has a checklist over there to see if I hit them all. Chris, recognizing that NetChoice, of course, reserves the right to advance any and all of these arguments, are there one or two you want to highlight for us before we turn to the litigators on here to go into the sort of details? The other litigators.
Absolutely. Thank you, Cody. So I think the biggest one is, the right to editorial discretion, because I think the rest of them sort of can fit under that umbrella. And what I mean by the right of editorial discretion is basically, the right of a publisher or the disseminator of news or the disseminator of content in general, their right to sort of make decisions about the content that they're going to host, the content that they're going to curate, and the content that they're going to disseminate. And so AADC infringes on the decisions that, the First Amendment protects in terms of that content and how it's curated and how it's shown to the public. But I would also say another very important component of this case in particular is prior restraint. And this is something that we don't really have in the other NetChoice cases that are pending. It's unique here. And I think it's actually probably the most important thing for the court to sort of look at is, like, even if you think that there are legitimate design problems with, how internets operate and so forth, and even if you think that this is just regulating conduct and not speech, there is still this problematic aspect of the fact that you have to complete, like, anytime you want to change your service, even a small change, you have to do this very comprehensive privacy impact assessment. And you basically have to, study how this is going to affect, minors and so forth. And then you have to sort of bundle it together and ship it off to the AG if he asks for it. And that is a prior restraint, right? Like, if there is breaking news and, Fox News wants to, put up a big new, like, website feature about, Hunter Biden is, arrested, and they want it to be interactive, presumably children might enjoy that because it's an interactive service. And as a result, before Fox News can even do that, it would have to do a data privacy impact assessment and make sure that it's, following this code. And of course, the code isn't specific, so it has to make educated guesses about what the Attorney General will like or not like. But ultimately, that is a prior restraint, right? Before you get to do something with content, you first have to study it and make sure you're studying it in terms of, whatever you think the AG is going to want. And that, to me, is pretty alarming. It's one thing to have lawmakers sort of require that you follow general data practices, how you collect, store, use, and so forth. It's a completely different story, though, if you have to, basically put in writing that you've done a bunch of studies and, in your best guess, it's going to comply with the law. But if it doesn't, don't worry, we're going to ship it off to the AG, and the AG can tell us whether or not we're in compliance. That is a huge chilling effect on online speech. And I think, given how punitive the penalties are, and given the reputational costs that come with having a state AG accuse you of, not wanting to protect children, it is going to chill a ton of speech. And, I do think that perhaps there are some corporations out there that might have the resources to have an entire legal team, dedicated solely to doing these, impact assessments. But for the vast majority of online operators, this is going to either shut them down or make it, very prohibitively expensive for them to innovate. And ultimately, that's going to affect content. And that's where we get into the speech angle. So I do think like the two big ones, right to editorial discretion, but also prior restraint.
And correct me if I'm wrong, the other net choice cases you reference are currently pending in the 5th and 11th circuits regarding common carrier laws or purported common carrier laws.
So yes, we actually have 2 cert petitions pending at the U.S. Supreme Court from Texas and Florida, and we are hoping that those will be granted for next term.
All right, thank you. So Adam, let's dig into the second First Amendment claim that Chris highlighted, prior restraint. Let's talk about fundamental concepts here. What is a prior restraint?
So generally speaking, a prior restraint is a government program or scheme that either prevents or discourages or deters speech before it can occur. And there are 3 aspects of this law that in our briefing, we identify as creating a prior restraint. And this is individually and collectively as part of the entire scheme of the law altogether. Chris has discussed the DPIA requirements, which is kind of like a classification scheme, very similar to the one that was invalidated in the interstate circuit case, which we discussed in our brief. The second is the age verification procedures that the law puts into place, which are similar to the sort of age gating regulations that were enjoined in cases like Marchese, which is the Third Circuit case, and there's a few others from that era enjoining sort of state versions of this COPA law that the Marchese case was about. The third concerns a provision that you addressed briefly, Cody, when we got started, which is sort of this rule that requires regulated services to enforce their content policies. And this is an interesting one. It's a lot like laws that were invalidated in the 20th century with respect to requiring movie exhibitors to enforce the Motion Picture Association of America's rating systems. It would be like, similarly, there's a case in Louisiana involving a violent video game, similar statute to the one that was enjoined in the Brown v. Entertainment Merchants Association case, where the state in that case sought to require video game publishers to enforce the ESRB rating system. So these are private rating systems. And the courts in these cases held that attempting to commandeer private rating systems, like whether a movie is rated R or not, or whether a game is rated M for mature, the state can't do that. The private groups can decide to rate content, but whether or not you adhere to that or correctly assess how content should be classified under those rules is not something the government can compel and hold you liable for. That's functionally what this rule requires. It's written in terms of, well, you just have to enforce your own content policy, but the issue is, well, who decides? And in this case, the government gets to decide whether you've done so and can bring an action against you if it thinks that you failed to do so. And that type of commandeering of private rules raises this proxy censorship concern, where the government can use private rules to regulate speech that it would not be able to regulate directly. So it can indirectly reach into private associations' rules to regulate speech that is protected speech. There's no category of speech that says that a film is too violent or contains maybe graphic content that's inappropriate for children under 17. That's an industry decision, but that's not a constitutional classification, right? Non-obscene speech that isn't obscene as to minors can't be regulated as categorically unprotected. And so the government can't reach into a private association's rules to attempt to enforce that. And that's similar to what we have here. So those are the 3 components of the law that we say operate effectively as a prior restraint in the sense of regulating how services publish content before they make decisions to publish.
And so if I'm understanding correctly, the DPIA and age verification qualifies prior restraint because they're sort of regulatory check marks that a publisher or an entity have to engage in before they can speak online. And then that third one regarding the content policies is sort of that government reaching in and co-opting a private rating system. Is that a fair kind of taxonomy here of the claims in the merits briefing or in the injunction briefing?
I would say that all three operate at a point before speech is uttered. But yeah, I mean, you've described the operation of the third in more detail. I would say that an important thing to understand for those who are listening and maybe aren't as deeply involved in prior restraints is that a prior restraint need not be like an express preclearance requirement to be a prior restraint. It's not like, it is like the clearest cut example perhaps of a prior restraint is like you have to go get a permit before you could say something in a public space. That could be a prior restraint in some circumstances, or you need to get a license before you can broadcast something. Like that could be a prior restraint in some circumstances. But the Supreme Court said that even informal attempts to suppress or discourage speech before it occurs can be a prior restraint, and that you have to look through form to substance, as the court said in Bantam Books, which was a case about an informal government commission which had no enforcement power, simply pestering intermediaries, people who would distribute bookstores, and suggest strongly that the books they were carrying were offensive to the morality of youth. And there was no preclearance requirement. There was no requirement. There was no even any sort of immediate risk of liability. But in that case, court said that kind of discouragement was in and of itself a prior restraint. And similarly, in the interstate circuit case, which I mentioned, which much like the DPIA requirements here, required in Dallas movie theaters to classify the content that they were going to display, to exhibit in their movie theater, and do so before they exhibited their films and report that, or have the material available to be reported. And the classification system in and of itself, in the risk that one could, by being forced to construct their own cage, so to speak, be prosecuted or targeted in some way for misclassifying or carrying speech that he was forced to acknowledge was harmful to minors in some respect, was a prior restraint as well. So these are flavors of censorship that have existed for some time. We're seeing them applied in new ways now, but there's nothing that's fundamentally new about the sorts of First Amendment problems that we have here. And I think that if my friends on the other side who are in the audience today, if you read their brief, what they would principally say is, well, none of this is speech, so it doesn't matter. And I think that that's fundamentally wrong, but that's their position, and I think it's very difficult for, and hopefully we'll get to hear from them on an event in the future, or we'll hear from them at the hearing. But it's very difficult to vindicate the position that they've taken if you acknowledge that what these laws do is regulate speech. It's impossible.
We're going to turn to another line of First Amendment doctrine here in just a moment. But Dana and Chris, I want to see if you have any reactions to Adam's comments on the prior restraint theory of harm here.
Go ahead, Chris.
Oh, just that I'm in full agreement. I think very well said.
I am glad that you're in agreement with your counsel. Otherwise, we might have unveiled some problems here.
Thanks, Chris.
It's always a good sign.
Yeah.
I mean, I'll say, the privilege of being an amicus is that you get to cherry pick which issues you want to address. So, you don't have to try and cover them all. And we, zeroed in on some very specific ones and didn't get into the prior restraint. But those are obviously important legal issues. And, speaking personally, I don't disagree with anything that Adam's just described.
Okay, so let's turn to, yes, Chris.
Oh, I do have one interesting tidbit. In our other net choice case that went before the Fifth Circuit when we sued Texas, Judge Oldham wrote a pretty interesting opinion. It was split 2-1, where he said that the original meaning of the First Amendment was to protect only against prior restraint. So to the extent that, the Fifth Circuit was sort of imagining prior restraint as, a ban on printing presses or something like that, I think that this case proves that that doctrine, even if you were to distill the First Amendment down to only banning prior restraints, it still has a lot of force. And I think, I'm excited to see how the courts respond to our arguments and how the case law sort of develops here. But it is, I think technology is straining some courts' ability to sort of think through the analogies and, how to sort of apply the historical context. But I, again, think that this case is going to be a great vehicle for the court to sort of take, traditional First Amendment principles and apply them in a context that keeps them relevant.
So let's turn to a First Amendment doctrine that's not for prior restraint, content discrimination. Adam, you raise in the preliminary injunction briefing that the age-appropriate design code's provisions constitute content discrimination. First, can you explain what is content discrimination and how is it involved in First Amendment jurisprudence?
Well, I'm not sure we use the phrase content discrimination. What we say is that the law regulates on the basis of content. And the significance of regulating on the basis of content in First Amendment jurisprudence is that it is one of many grounds on which you could trigger strict scrutiny, which is sort of the way that a framework of analysis, accepting sort of special doctrines like overbreadth and vagueness and prior restraint, which we also argue and we've discussed. The traditional First Amendment jurisprudence that a lot of folks are probably familiar with in this room or in this webinar is that when the government regulates speech on the basis of content, you require them to show that the regulation is the least restrictive alternative and is narrowly tailored to advance a compelling state interest, which is the strict scrutiny standard. So the policy rationale for this jurisprudential rule is that when you're regulating on the basis of content, we're worried about the sensorial effect that the law might have, that we're trying to silence speakers based on their ideas, or we're trying to limit the type of information that we permit to disseminate in open society. And in our republic and in our tradition as a country that has a robust, uninhibited, and wide open public forum, these types of laws are, with the exception of prior restraints, the most noxious that you could potentially enact. And so we want to be extra careful that you have an extremely good reason to regulate speech on the basis of its content, and then only to do so if it's the least restrictive way to achieve that interest, if it is narrowly tailored to achieve it at all. So in this case, the law at issue, which is interesting because it's an omnibus law. Usually you're challenging a law, it's one of these things that we challenge. This law is full of a variety of different provisions, but each individually and collectively and overall, the law regulates on the basis of content. I won't get into all the ways that the Supreme Court and Reed described what constitutes content-based regulation, but what I'll say here is that fundamentally, the law requires services to make distinctions about the publication decisions they make based on whether the content they're publishing, whether it's third-party content or original content, is going to harm children in some respect, or is going to be materially detrimental to their interests. And these terms aren't defined, but at a minimum, what the Supreme Court has said in cases like Ashcroft, the ACLU, is that when you're requiring any speaker to make a distinction between speech based on its likelihood or potential to harm children, it's content-based, because you're whether something harms someone requires you to assess what it is that's being spoken. And I encourage everyone here, if you do nothing else after this meeting, and I say this as someone who's a left-leaning Democrat, I encourage you to read the Brown v. EMA decision from Justice Scalia, which is just a tremendous decision, really enjoyable, well-written, and elucidates quite clearly both why I think that we will and should prevail in this case, but what the importance of the First Amendment to speech that's made available to people under the age of 18, fundamentally, which is what a lot of these laws are about. So in this case, just to be specific, and I'll stop talking, the law is content-based in the sense that at a high level, it's about the protection of children, yes, but it's also specifically content-based in a number of different respects. The DPA requirements, apart from the incorporation of the harm standard, which is a content standard, compel speech. The Supreme Court has held that when you compel someone to speak, you are, by the nature of that regulation, altering the content of speech by creating speech that would not otherwise exist, and that is a content-based regulation subject to strict scrutiny. And in this case, it's not commercial speech, right? This is editorial speech that we have to publish to the government. The law is clear that it can't even face consumers. Only give it to us. That's a archetype of a speech compulsion that is subject to strict scrutiny.
I want to move on to talk about Dana's brief. I do want to give you one opportunity to clarify one that was made early on, which is you mentioned the Brown v. Entertainment Merchants Association case.
Yeah.
And one line that is often parroted is that the Supreme Court said you can regulate content that's harmful for children. In light of Brown v. EMA, what do we learn about that word harmful to children?
Well, what Justice Scalia wrote for the court in that case is that the regulation of non-obscene there's no basis to regulate non-obscene content for children. So there's an obscenity standard. Obscenity is this type of speech which is not fully protected by the First Amendment. And there's a modified obscenity standard with respect to speech that is presented to children. And that's what's recognized in cases like Ginsburg. But what Scalia makes absolutely clear is that there's no basis to regulate non-obscene content that children can send and receive. And so there's no attempt in this statute to incorporate the Ginsburg standard, whether or not saying that's what they're doing would have been sufficient in the first place. But by not doing so, there's no question that the type of speech that is regulated in this case, under the statute, far exceeds speech that would be obscene to children. In fact, if you look at the statements that legislators make, and if you look at the front matter to the bill itself, I mean, it identifies speech that it concerns violent content or speech that might.
Well, frankly, far less controversial than that. In briefing, California specifically highlighted as an example, diet pills,
Yes.
that it would be potentially harmful to children for them to see an advertisement for a diet treatment or a diet pill. That is content that is absolutely lawful, not obscene, but that was the example that was given.
Yeah, it's for the New York Times especially. I mean, you can imagine all types of content that the New York Times carries, which maybe involves podcasts on emotionally upsetting subjects, right, or news reporting on difficult or difficult images, right? I mean, all of these things could be covered by the law.
Yeah, and in our briefing, we highlight the fact that the news is upsetting. The news contains explicit images. It contains accounts of violence. It grapples with issues around gender identity and sexuality and crime and abuse. We think about some of the most important content that we produce. As an example, we recently produced a award-winning video identifying responsibility for war crimes in Ukraine. Very detailed video investigation. Much of that video is very disturbing by its nature, right, in terms of proving that Russian soldiers murdered Ukrainian civilians. I have a 7-year-old daughter. I have not shown her that video. I have no intention of showing it. It is not an appropriate video for her age, but young people deserve to have access to that kind of information. They are fighting and dying in these wars, and so who gets to decide whether or not that is content that's potentially harmful? And I don't think in our current political climate, it's not a hypothetical question that regulators might have very different views on what is potentially harmful to children. We highlight in our brief, for example, Governor Newsom, I think, has highlighted, for example, information about dieting or around kind of weight loss. I suspect Governor DeSantis has some very different ideas about what is potentially harmful to children, as we've seen play out in regulation around the kinds of books that are available to children. You know, depending upon what your social, religious, political perspective is, there can be very different answers to that question.
Yeah, and I want to drill down on that for a moment here, Dana, before we turn to some of the questions, because we are coming up on time here. Can you talk to us a little bit more about the argument in your briefing that this law impacts the First Amendment rights of minors? And I will note again that you filed not just on behalf of the New York Times, but the Student Press Law Center. So can you tell us a little bit more about minors' First Amendment rights here?
Yeah, so kind of missing from a lot of the debate about these laws has been the voices of young people who are affected by them. They don't tend to have the resources to hire fancy lawyers like us. And so we partnered with the Student Press Law Center, which has long been a very important advocate for student press, to make a full-throated submission about the importance to young people of access to news, to this kind of content that this code would restrict. And we set out in the brief that there is a long and distinguished history of young people leading social movements, being involved in shaping the way that we view the world. Everyone from Mary Beth Tinker to the Parkland students, and they have First Amendment rights to access lawful content that's not obscene. The Supreme Court has repeatedly affirmed that. Adams just highlighted the Brown decision, and I agree with him that it's a very important decision to read, I think, in this area. The court, has repeatedly affirmed that young people have First Amendment rights that outside of the school context are potentially equivalent to those of adults, again, accepting obscene content. As recently as I think last term, Justice Alito in a concurrence, restated that outside of the school context, the student at issue, her speech clearly could not have been curtailed by the state.
The Snapchat cheerleader case. Go ahead.
Exactly. Mahoney, I think, right, is the case. So we felt that it was important to make that affirmative case for young people having access to content online, that it's not just a matter of protecting children, that limiting this content actually does harm in itself.
That's excellent. Now, for the audience, we had a whole section prepared here about COPPA preemption in Section 230. We are at time, and so I don't want to drift us far from our First Amendment issues here. There's some great questions in the chat I want to be sure to talk about. But let's step back once again to a high level. We've talked a lot about the First Amendment today, about privacy and about design, which, the design code is about more than privacy. Obviously, it's in the name. Is there a way to square these First Amendment considerations with privacy as a general matter? What would that look like? Very easy question, of course. And that is for everyone. So whoever has the courage or is foolhardy enough to try to dive in.
I think just to jump in a little bit, I think one of the challenges with that question, right, is goes back to what Chris highlighted at the very beginning, is this even a privacy act?
I'll just say, NetChoice does support a federal privacy law. We have supported some state laws. Ultimately, I think it gets to what Dana's saying, you have to be very clear about what you mean by privacy. And I think that the law should try to do no more than to perhaps create some basic rules of the road or best practices for data collection, use, storage, and whatever, right? I think that's traditionally what we think of by privacy. I don't think that privacy should be expanded as a concept to suddenly encompass, online harms like, speech, right? I think as this conversation has shown, there is little agreement on what constitutes harm. I mean, for First Amendment purposes, we know what isn't harm that can be regulated. But I do think that privacy laws are successful when they stay narrowly tailored to the issue at hand, which is usually data collection. And I think that that is where lawmakers can be most fruitful. To the extent that lawmakers have broader concerns about, privacy insofar as it's a, like an individual right or that type of thing, I think then we just have to look to users, because at the end of the day, there really is no one size fits all for how Americans view their online data privacy. Like, I am happy to give up quite a bit of my data for targeted ads, but I would not really like it if, every message I ever sent was being read. But my views should not be dictating what the law is for the whole country, nor for that matter, should our actual elected officials.
Yeah, I mean, just to add, I mean, California has a very comprehensive privacy statute that folks on this call are probably very familiar with, or certified professionals at implementing and advising compliance with. Other states have copied that law. We don't challenge that law in this case, and to the extent that the law at issue, the design code, is actually a privacy statute at all, I'm not sure that it is. We would point to these existing laws as the better way to get at those interests. What this law really is a regulation of speech. It's a law designed to sanitize the internet, to make it safe. It is dressed up in the language of privacy. And this is a meeting of the privacy section of the California Lawyers Association. But the interesting thing is that this is not a privacy statute in the traditional sense of what we understand those statutes to be, which, as Chris said, focus on collection of user data, obtaining consent, and so on and so forth, which you can do provided you're complying with First Amendment restrictions, which for the most part these statutes have been held to do.
Excellent. So in our remaining 180 seconds together, first, Adam, very quickly, what does the timeline look going forward? And will this alleviate businesses of having to prepare for the law, which is a question that is in the chat here?
Well, unless our injunction is granted, no, it doesn't. And in fact, we've submitted affidavits illustrating that folks right now, as many of your clients might be for folks who are in attendance, are doing things right now to comply. And so the timeline is that we have a hearing in July. We've made it very clear that we want a ruling as quickly as possible, so that if there are appeals, they could be taken and exhausted. The Ninth Circuit has an expedited procedure for appeals of preliminary injunction motions. So we would hope to have a ruling before the end of the year, and hopefully a favorable ruling before the end of the year, permanently enjoining the statute, or at a minimum providing some relief so that services aren't unsure as to what will happen during the pendency of the appeal, should there be one.
And one last question in the chat here. There are state laws trying to add age verification for constitutional obscenity, as we noted at the top. That, of course, can chill adults' access to speech as well. Does that concept figure into the age-appropriate design code or into this lawsuit?
Yeah, the quick answer there is the Marchese case, which I mentioned before, and the PSI Net case, and a few others. There's some out of the district court in South Carolina. There's a number of these baby COPA cases, which all held that age verification statutes, even with respect to pornography, they chill speech and offend the First Amendment, both with respect to minor speech, but also in perhaps in some of those cases, principally with respect to adult speech, because folks don't want to identify themselves before they're able to access lawful content. So the law is overbroad in that respect as well. It affects adult speech for sure. That is an issue in this case. Yeah, and Ashcroft v. ACLU is probably the leading Supreme Court case, finding that requiring credit cards to verify age was an improper prior restraint. And Marchese was a decision on remand when it was sent back down to the Third Circuit.
Excellent. All right, let us have a quick whip around for closing thoughts, whatever you want to offer in our last minute here together. Dana, we'll go ahead and start with you.
I think my closing comment would be, going back to the idea that a lot of this has been framed as sort of a tech issue or only affecting tech companies. But I think it's really vital for listeners to understand that this is an issue that this particular code reaches far beyond just social media and tech companies. But that also, those of us who are litigants or amici or whatever in here, obviously we have our industry interests. But when it comes to First Amendment issues, the press, for example, the New York Times, our rights are the same as any other person and individuals' ability to engage online, to research, to speak, to communicate with others, to access sensitive content anonymously is being affected here. Everybody should be interested in these issues and caring about this. And whether it's this code or another patterned like it or others that are in the works, I think that there is and I'm speaking personally here, I think that there is, the internet as we have known it sort of in our lifetime potentially could look very different depending upon whether or not these acts are upheld.
Excellent. Chris, I'm going to give you the last word as a matter
Oh
of
boy.
Plaintiff's privilege. Adam, briefly, anything to add to what Dana said before we turn to Chris?
No, just to reiterate, this is an important case. It's a privilege to be able to bring it on behalf of NetChoice. Hopefully, we will see that these state laws aren't successful insofar as they attempt to fundamentally reconfigure the types of First Amendment protections that apply online. We look forward to vindicating that right and look forward to working with Chris and Dana in the future on these types of issues.
And Chris, the last word.
Well, I second everything that was said by them, and I'll just say, look, words are not violence, but if speech didn't have an impact, we wouldn't go to such trouble to try to protect it under the First Amendment. So it is clear that speech can have, harmful effects on people, and it's not wrong for lawmakers to be concerned about that. But ultimately, the vibrancy of the internet, the fact that it gives a platform to everyone, regardless of their status in life, the fact that you can get so much content and knowledge for free, that you can be reading the news from so many diverse sources, that is the true benefit of the internet. And it is put completely at risk by laws like AADC and age verification. And it's also just consistent with a historical overreaction to new technology and the new concerns that come with, a flood of content and so forth. But ultimately, this really comes down to what is the internet that we want? What does it look like? And I think I speak for the vast majority of people that we may not 100% love what we currently have, but it's definitely better than an internet run by the government or an internet that is, censorship by proxy, as Adam put it. Ultimately, these laws do have an effect on the internet and the user experience. And so, like Dana was saying and Adam was saying, everybody should be concerned, regardless of, if you're a privacy absolutist or not. This is just not the way to go about it.
Excellent. Well, thank you to all of our great speakers today. It's been a pleasure having you. And thank you to our audience for attending. This wouldn't be possible without you here and your input. To everyone, have a great day. Keep your eyes peeled for hopefully the second portion of this series of webinars. And thank you very much.
Thank you. Thanks for having us.
Thank you.